Hello everyone. We are going to discuss Patent Agent Exam 2013, paper 1 today, along with their answers and explanation. This paper consisted of two separate parts, and part A was for actually 40 marks. In that, part A1 was for 30 marks, wherein 15 multiple choice questions were there of 2 mark each. Part A2 was of 10 marks, which was true or false type of questions. So we are going to just discuss this part because the next part in paper 1 was long answer question or case-based questions. We would be discussing it in some other session. Today we'll be just discussing about the short answer or multiple choice and true or false kind of questions here. The first question is the statement and undertaking regarding the filing of foreign application by an applicant shall be filed. There are 4 options given: within 6 months of the filing of such foreign application, immediately after grant of the foreign patent, and simultaneously on the date of foreign filing. The 4th option is within 1 year of the filing. The correct answer in this case is within 6 months of the filing of such foreign application. This is in Form 3 under Section 8.1 under Rule 12.1a. You need to remember the difference between Section 8.1 and 8.2. 8.1 is it is your duty to submit the information under Form 3, and under Section 8.2, which is different from 8.1, the controller at any point of time can ask for such information to you. Question 2, a divisional application may be filed by the applicant. 4 options given are within 6 months from the date of filing of provisional, within 31 months of the filing of a convention application. Option C is anytime before grant of the patent on the first mentioned application and before publication of the patent application. The correct answer to this is C. The divisional application can be filed anytime before grant of the patent of the first mentioned application. This is covered under Section 16.1, power of controllers to divide the applications basically. Now, the appropriate court for institution of a suit for infringement of patent. Herein, 4 options are given: district court, high court, IPAB, and the 4th option is A or B. Now, if you look at this, the first and second option are also correct, but since this is a multiple choice question and we have to select the most correct answer, herein the answer would be D, A or B. This is under Section 104. The suit for infringement is filed in a court not inferior to district court. So that is district court and above. Question 4, in setting the terms and conditions of a compulsory license, the controller shall endeavor to secure. Now there are 4 options given: that the license granted is exclusive and non-assignable. That's a wrong answer because the compulsory license is always non-exclusive. Second, that the license is for a period of 20 years from the date of grant of a license. This is not applicable at all. Reason being, the license is basically for a fixed tenure, first of all. And second thing, 20 years from the grant of a license, till that time, the patent would have already been expired because CL is applicable only after grant and when 3 years have been passed, as well as the invention has not been worked out. So the correct answer to this is D actually. C says the invention is worked to a reasonable extent. If you look at Section 90, in that you would see that none of these clauses are included. The invention is worked to fullest extent. That's what is mentioned under Section 90. Question number 5, information related to an unpublished patent application. Application which is not published and filed at the Indian Patent Office can be obtained by any person. Now the options are immediately after filing the application, on payment of prescribed fees, by physical inspection of the file at the patent office, and D is none of the above. Now the patent application before publication is actually secret. No one has access to it. Even patent office doesn't have access to it actually. So the correct answer here is none of the above. Question 6. When a patent is sought to be revoked on the ground of wrongful obtaining from the first and true inventor, the controller may, option A, direct that the patent shall stand amended in the name of opponent. B, direct the person wrongfully obtaining to pay penalty to the true and first inventor. C, revoke the patent and ask the rightful inventor to apply fresh for a new patent. D, direct the central government to pay compensation to the inventor. The correct option in this case is A. It can be directed that the patent shall be amended in the name of the opponent. Just look into section 52. You would come to know this is the correct answer for this. This is not in case of opposition, but this is in case of revocation. This is in case of revocation. Now, in which of the following cases appeal shall not lie to the IPAB? The four options given are refusal under section 15, post dating under section 17, decision of controller under section 54 regarding patent of addition, and finally deemed to have been abandoned under section 21. First thing, IPAB is dissolved now. It's no more applicable, but this question was there in the previous question paper. That's why we are taking it. And the correct answer to this is actually D. If you look at section 117A, in that case, you would see that in that appeals part, section 21 is not there, which is about abandonment. Also, there was a case law in the year 2009, Erickson versus Union of India, in which this matter was discussed actually in detail, because the application, although the applicants in that case had specifically replied to the examination, but still the controller had abandoned the application under section 21. That made the applicant not to pursue the appeal. So instead, the matter went to the court, and therein in this particular case, section 21 was discussed in detail. So the correct answer here is section 21. This question also repeated in 2018. Question number 8, when an application for patent is published but not granted. So application is published, but it's under prosecution. Any person can oppose the patent application on the following grounds. So this is the typical case of pre-grant opposition, because the patent is not yet granted. Based on the grounds, non-payment of prescribed fees, non-disclosure of financial assets by the applicant has not provided an address for service, and the fourth is the invention is anticipated having regard to the knowledge of indigenous community in South Africa. Now, if you see first, second, third, these are not the grounds for pre-grant opposition. The fourth is the one wherein, under section 25(1), which is for pre-grant opposition, this particular clause is already included, which is about the traditional knowledge. Also remember, the grounds for pre-grant opposition and post-grant opposition are exactly the same. 25(1) speaks about the pre-grant, and the 25(2) speaks about the post-grant opposition. Question 9, the controller in any proceedings before him under the Patent Act has the power of civil court while trying a suit under the Code of Civil Procedure 1908 in respect of following matters. So in few cases, the controller also has power under the civil court, and this and what are those matters basically, or in what respect? First, passing an order regarding search and seizure of infringing products of an opponent who has filed a post-grant opposition. This is a wrong answer actually. B, requiring the discovery and production of any document. C, receiving evidence by way of declaration. D, passing an order granting interim injunction against the alleged infringers, basically. Now, the correct answer in this case is C. The controller cannot seize infringing goods. Controller cannot give an order against interim injunction. See, the enforcement of the patent comes under the I would say in the broader purview of the courts and not the patent office, basically. Also, the controller cannot require the discovery, or like they cannot order the discovery and production of any specific document in front of court, in front of controller, basically. But receiving evidence by way of declaration, what we also call in few cases, so we submit in many cases the affidavits as well. So that is something which is allowed. This is covered under section 77. Question number 10. One of the following is not true in relation of patent of addition. Now, patent of addition are the inventions wherein if there is a slight modification or any improvement in your previous invention, you file patent of addition. If the patent for main invention is revoked, the patent of addition may continue as independent patent for the remaining. This is a true statement. Renewal fee is to be paid to keep the patent of addition alive if the main patent is revoked. This is also correct. Patent of addition can be granted before grant of the main invention is a wrong answer. The term of patent of addition is generally less than the term of patent of main invention. That's also a wrong answer. That's the true statement. What is being asked is the false statement, and the correct answer in this case is C. This is as per section 54(4) that the term of a patent would be same as that of the patent of addition, or vice versa. The term of a patent of addition would be same as that of the main invention, basically. Question 11. Identify the option in which Ramesh and Suresh cannot be inventor as per the Indian Patent Act. Option 1, A, Ramesh and Suresh work for the identification of a novel process in the lab. They can be inventors in this case. Ramesh finances Suresh work for identification of a novel process in the lab. Now, in this case, Ramesh cannot be an inventor because he can be a assignee or applicant, but he cannot be an inventor. The question is very specific with respect to the inventors. Ramesh from US and Suresh from India work on identification of a novel process in the lab. Two separate inventors from different countries are allowed to be co-inventors in a patent application as per Indian Patent Act. Ramesh conceptualizes the invention and joins Suresh in reducing the invention to practice. So if you look at this, the correct answer is Ramesh cannot be a inventor if he just finances and he is not involved into actually the invention. Now, if you look at the inventorship, as far as the Indian Patent Act or Indian context is concerned, there are two bases for inventorship. One, who has conceptualized the invention, and second, who has the reduced the invention to practice. If you look at the option D, actually, that's the case wherein the inventors, those can be called as inventors. But if you are just financing, you can be an applicant, you can be an assignee, but you cannot be an inventor in that case. Now, one of the following is not a ground for pre-grant and post-grant opposition of a patent in India. Now, again, section 25(1), section 25(2). Wrongful obtaining is one of the grounds. Non-disclosure or wrong mentioning of geographical origin of biological material is also a ground. Complete specification does not sufficiently clearly describe the invention. That is also a ground. So the correct answer herein is the D. I have gone through that elimination route. Basically, I didn't know the exact answer, but I knew these are the three grounds, and the right answer is it was secretly used in India. And as I said, 25(1) and 25(2), these are the sections for pre-grant and post-grant opposition. The grounds are exactly similar in both the cases. A provisional patent specification must contain description, claim, abstract, or background and prior art. Now, in this case, the correct answer is description. If you look at section 10(1) specifically, a provisional or complete specification must contain description of the invention. Now, in case of provisional, claims are optional. Abstract, actually, you have to submit the abstract, but I think the most appropriate answer in this case would be description. Background on prior art, of course, can be missing. Question number 14, in case of request for permission for making patent application outside India, this is foreign filing license, the controller shall dispose of the request within a period of, this is at 21 days actually is the right answer for this. This is section 39 about the foreign filing license. Question number 15, a post grant opposition may be filed by any person. No, that's wrong answer. Reason being, only person interested can file before the expiry of period of 12 months from date of publication under section 43 or 12 months from the date of publication under section 11A. Now, what do you mean by section 43 and 11A? 11 is a publication of an application and 12 is a publication under grant. So C is again eliminated. That's a wrong answer. Now the confusion is between B and D. Before the expiry of a period of 12 months from date of publication under section 43, which is a grant, or before the expiry of 12 months from the date on which the controller writes in the file granted. But herein we can again eliminate the option D. Reason being that third party may not come to know that this particular patent was granted until and unless it is published in the Gazette. So that Gazette publication works as a basis for post grant opposition. So these were the 15 questions for multiple choice for 2 marks each. Let us move on to the second part, A2, wherein you have 10 questions, 1 mark each, and you have to answer true or false for them. Now, the first question is revocation of a patent on the ground of being mischievous to the state or prejudicial to the public can be done only by the High Court or application by any person interested. This is a false statement. This is not a revocation ground under section 64, mischievous to the state basically. Okay, this is not a ground. Question 2, if an applicant for a patent who has filed a provisional files a request for early publication, before filing the complete specification, the application will be published within 1 month from the date of filing of such request. This is a false statement because you cannot file the early publication request for a provisional application. The publication happens only when you file a complete application. So this is also a false statement. It is mandatory to describe the closest prior art in a patent specification. Nowhere in the Patent Act it is mentioned that it is mandatory to describe the closest prior art. But as a practice, it is always recommended to include the closest prior art or all the relevant documents in the prior art, or what we also call as the background part of the patent specification actually. Question 4, in order to get an assignment registered at Patent Office, the application has to be filed for registration before expiry of 6 months from the date of assignment. This is again a false statement. There is no specific time limit for this. So once the assignment is done, you can actually submit it for the registration at the Indian Patent Office. Question 5, an exclusive licensee of a patent shall also have the right to sue for infringement of patents in any district court, adding the patentee as a defendant. Now, this is something which is, I would say, a bit confusing, because exclusive licensee, if he can file a suit basically for infringement in any district court, why? So that suit would be against the infringing party. Why would the patentee be a defendant. But this is a true statement because under section 1092, if you see specifically, if the patentee is not willing to be a plaintiff, so plaintiff is the one who files the case, defendant is the one who has to defend the case. In that case, it is allowed for patentee getting added as a defendant. So an exclusive licensee actually can do that. Question number 6, use of a patented product for the purpose of development and submission of information before the DCGI. So there is a patented product for which is used for development and submission of information before DCGI, which is a regulatory agency in India for the pharmaceutical product, is not considered as an infringement. This is a true statement under section 107A. Any use which is meant for the submissions to the regulatory agencies is a exemption. It's not considered as a presumed as a infringement basically. Question number 7, a model or sample of anything illustrating the invention or alleged to constitute an invention submitted by applicant to supplement the application in compliance to direction of the controller shall be deemed to be part of the specification. This is a false, this is a wrong statement. Under section 10, if you see, the controller can ask anytime for a model or a sample for the invention, but it would never form the part of the specification actually. Question number 8, a patent may be revoked on a petition of any person interested or central government by Appellate Board or a counterclaim in a suit for infringement of the patent by the district court on the grounds specified under the act. Now this is a false statement. If you look at section 64(1), then the revocation always happens at the high court. Actually, it doesn't happen at the district court. So a patent may be revoked only in the high court. Herein it is mentioned as district court. That's the reason it's a false answer. Question number 9, when secrecy directions are enforced, controller shall not pass an order refusing to grant the patent. Is a true statement. Just go through section 37(1), 1A, section 37, which is about secrecy direction, would give you more clarity about this. Last 10th question, priority of an application filed in a convention country cannot be claimed if the application filed in the convention country is withdrawn before date of filing of the corresponding convention application in India. This is true, reason being one of the logical reason in this case may be that the applicant need to provide the priority document while submitting the convention application actually, and if that application is withdrawn, you may not be in a position to get the priority document. So this is a true statement actually. And thank you so much for joining in for this session actually for Patent Agent Exam 2013 paper 1 answers with explanation. I'll again get reconnected with you with some other question paper discussing the multiple choice answers along with explanation, as well as we'll be discussing in the later part the different questions in paper 2 as well. Thank you so much.